Again, it is an honor and a privilege to be asked to speak before the symposium again this year. And thank you to my distinguished colleagues, John Payon III and Victoria Payon Rosa, for assisting me with the materials which appear at page 1 of your booklet. Hey guys, stand and be recognized by this generous crowd. I would be remiss if I did not remark on the great job that Cheryl Connors is doing during her year as chair of our section. Let's hear it for Cheryl. You know, when you take the job as chair of the section, especially this new generation, I know they plan and they prepare for their year as much as possible, but you really never know what you're going to get hit with. And for this year, obviously, Cheryl got hit with the legislature becoming very active in our field of practice. And this doesn't surprise me, because as there are fewer and fewer cases that evolve through the system and generate case law, people who look to change the law, shape the law, mold the law, have to go to other venues. In this instance, it was the legislature. The problem, of course, is when the court shapes and molds the law, it uses a surgical pen. When the legislature shapes and molds the law, it uses a butcher's knife. And I don't expect things to get any better, because with the success of ADR, mediation, arbitration, I see fewer and fewer cases making its way through discovery, all the way through trial, up to the appellate division, and then having a reported opinion. And so you will see today, again, of our top 7 of 10 cases, most come as a result of appeals from domestic violence matters, post-judgment cases, and some aren't even family cases, but which we innovatively present to you today as part of the top 10. Let's talk about happier things for the moment, if we can. Last week I spoke on a panel with Cheryl, and we were talking about how excited we were about this day and all. And she says, you know, I only wish that we could have a crowd as big as we had prior to the pandemic. And, you know, she did a pretty good job today. She's got over 500 people, which I think post-pandemic is a record, huh? But not being outdone, I said, Cheryl, we could do better, because I've got an idea. Next year, what we're going to do is we're going to announce that one of the presenters is going to be Taylor Swift. And I don't mean any of these faux Taylor Swifts up here, although I will tell you, Gerald Lawrence does make a very nice terrible Taylor Swift. I mean the real Taylor Swift. And Cheryl said, John, how are you going to do that? Do you have a connection with Taylor Swift? I said, no, not at all. I don't even know anyone involved in her. We're just going to announce that Taylor Swift is going to be here, and then when everybody gets here, it's just going to be us. She said, John, isn't that unethical? I said, Cheryl, you think it's unethical, and I might think it's unethical, but I don't know if the New Jersey Supreme Court thinks it's unethical. And so let me turn your attention to our first opinion this morning, which is In Re Opinion number 735, 260 NJ 482. The issue here is not that someone is using the name of Taylor Swift. No, the issue here is that people, other attorneys, our colleagues, mind you, are using the name of well-known attorneys as keyword search terms. So when a prospective client goes to the internet to search for Gary Skoloff, hearing that he is a great family law attorney, the search takes you not to Gary Skoloff's website, but to Attorney X's website. Why? That's because Attorney X purchased from Google or Yahoo or Bing the name Gary Skoloff as a keyword search term. And the question before the Supreme Court in this case is whether or not this practice violated the rules of professional conduct. Now, if you're like me, and I suppose Cheryl, you have that skeevy feeling at this time. You know, it's that sixth sense that you have when something goes on in your practice that you know is just not right. And I'm not an ethics prude. I believe in robust attorney advertising. And I think most people in this room agree with me on that. But understand, we're not talking here about an attorney purchasing keywords like divorce or alimony or custody. No, here we're talking about an attorney purchasing the name of an individual who, after many years, has built a respected reputation among judges, attorneys, and clients. Buying someone's name doesn't sound to me like puffing and bragging. You know, I'm the best lawyer ever, I'm the super duper lawyer. Buying someone's name sounds more like theft of a proprietary interest. And furthermore, the individual whose name is being purchased is not being compensated, has not consented to this, and in most instances doesn't even know it's happening. Now, to the credit of the New Jersey Supreme Court, before they decided this matter, they decided to have a special hearing master. And they listened to the input. And they heard from the New Jersey State Bar Association, which said that this practice is wrong. And they heard that other states had also found that this practice was wrong. But this wasn't persuasive enough for our Supreme Court. They held that the practice of purchasing the name of a fellow practitioner as a keyword was not unethical, as the court could find no evidence of intent of dishonesty, fraud, deceit, or misrepresentation on the part of the attorney making the purchase. To which I ask, what other purpose could there be for someone to buy somebody else's name other than to deceive the public, who's searching for attorney Skoloff, but they're directed to attorney X? If the pole star of attorney discipline is to protect the public, then there can be no justification for permitting such behavior, regardless of intent. Now, despite finding no intentional misconduct, the Supreme Court said that if you do purchase another attorney's name and the unsuspecting member of the public gets transferred to your site, a precautionary disclaimer is needed. You know, just like the disclaimer we used in 1965 on the back of the cigarette package. Caution, cigarette smoking may be hazardous to your health. This disclaimer reads as follows. You arrive at this page via a paid advertisement on Google through paid keyword search result. This website and the legal business it describes are affiliated only with attorney X and the other attorneys referenced within the website. I believe the Supreme Court lost sight of the fact that it was not regulating the sale of soap or cigarettes, but it was regulating attorneys who are held to a higher standard than what is condoned in the regular marketplace. Now, at this point in time, I'm needing a sanity check because I'm reading this opinion. I say, how could I be so wrong? Have I completely lost my ethical compass? And fortunately for me and for all of us, we're given some comfort by a dissenting opinion from Justice Fasciali, who writes the following, quote, to secretly appropriate for oneself the earned goodwill and reputation of another lawyer or firm solely for personal financial gain violates RPC 8.4c and its prohibition against engaging in conduct involving dishonesty, fraud, deceit, or misrepresentation. So, at the end of today, when you drive home, you meet one of your friends, and they ask you, hey, is it true that I heard that Taylor Swift is going to be appearing at the symposium next year? You tell them it's highly likely. Case number 2, MA versus JHM. Well, the question in this case, again by the Supreme Court, is can a defendant take the Fifth Amendment in a domestic violence case without a negative inference being drawn against him? Now, if you're paying attention, and if you were here last year, you've got to be saying at this point, what am I, in some kind of a time warp? Didn't we do this already? And you're right. We did report last year on a case called TB versus IW, an appellate division decision written by our friend Judge Hanny Mala. But in fairness, MA is a case that was winding its way through the system before TB got published, and this now is the Supreme Court's final word on this issue of taking the Fifth Amendment in domestic violence cases. To properly understand MA, let's go back and review what happened with TB and the appellate division's handling of that matter. Remember that unlike criminal matters where you can take the Fifth Amendment without any consequence, the general rule is that if you're in a civil matter and you take the Fifth Amendment, the court can draw a negative inference. Now, we know this because in our practice, we come across it oftentimes in the Sheridan cases, right, where someone has committed some kind of tax fraud, they're not going to produce records, they may not answer questions. The court can draw a negative inference. Why? It's to level the playing field. You're not giving me discovery, you're not telling me what's going on, we're going to draw a negative inference against you. But in TB, the court said that domestic violence cases are different than other civil cases. In domestic violence cases, the conduct is defined by the criminal code itself, making them kind of like quasi-criminal cases. FROs don't expire and they theoretically last forever. DV penalties include being fingerprinted and placed in a domestic violence registry. A DV FRO can result in a potential loss of employment, prohibition against owning a firearm, and it can impact child custody and parenting time. And finally, violation of an FRO can result in a criminal contempt proceeding. So unlike other civil matters, the consequences of a finding of domestic violence are very high. And the Appellate Division held that even though the Prevention of Domestic Violence Act immunizes the testimony of a party in that proceeding in an unrelated criminal proceeding, that's still not as good as the Fifth Amendment. Because with the Fifth Amendment, you cannot then use that testimony in an unrelated proceeding because it doesn't exist. With the Fifth Amendment, you can't use the same testimony in a related proceeding for impeachment purposes. So because we wanted to give the defendants that protection, the Appellate Division then said there is no negative inference to be drawn. Final thing to keep in mind in terms of what the Appellate Division said in TV is that unlike civil matters, in domestic violence cases, the plaintiff holds in her hands all of the facts necessary to prove domestic violence. There's no unfair advantage by the defendant claiming the Fifth. And so the law was left that defendants can take a blanket immunity taking the Fifth Amendment in a domestic violence case. Now let's get back to MA, which is the case now before the Supreme Court. And when you read it, you say to yourself, the first thing that hits you is, boy, this is a weak case. Even though the plaintiff has a TRO, her allegations seem very weak. She alleges stalking. What's the stalking? She says the defendant drove by her parents' home at a high rate of speed, almost colliding with her brother's vehicle. She alleges harassment. What's the harassment? She says the defendant telephoned her at work, although the telephone ID didn't identify it as the defendant, and then when she picked up the telephone, it wasn't the defendant on the line. Now, the plaintiff's attorney saw that the case was weak. So what does he do? He calls the defendant as a witness in his case in chief. And kudos to the defendant attorney, because he appreciates that the plaintiff's case is weak. He announces, my client's taking the Fifth Amendment. The judge, who knows the law, says, I just got to tell you guys that if in fact you take the Fifth Amendment, I'm going to draw a negative inference against the defendant, because that's what the law is. Remember, this case is decided in the trial court before TV got reported. To the credit of the trial judge, he agrees to stay the trial because the defendant's attorney is going to take an appeal. So the defendant's attorney does file leave to appeal with the Appellate Division, and the Appellate Division denies the leave to appeal. Well, that's generally the way it works with these interlocutory appeals, right? Oh, try your case, lose it, come back to me and I'll give you justice. Try your case, win it, you don't need me, I save myself a day's work. That's the way it's supposed to be. But the defendant is not deterred. He's going to file a motion for leave to appeal to the Supreme Court. Now, I'd be willing to bet that we have a better chance of not having snow tomorrow than the Supreme Court's going to take a case that hasn't completed trial at the domestic violence level. The Appellate Division hasn't already taken it. But wonder of wonder, miracle of miracles, the Supreme Court takes the case. And the Supreme Court holds that TB and the Appellate Division got it right. That is, you can exercise your Fifth Amendment right in a DV case without there being a negative inference drawn. However, the privilege is not a blanket privilege, and you have to go question by question in the domestic violence proceeding to determine whether there is, quote, reasonable cause to apprehend danger from a direct question. And so if the question is innocuous, such as, are you married? You must answer. You cannot plead the Fifth, and if you do plead the Fifth, an adverse inference will be drawn. To which I say, what kind of an adverse interest are you going to draw when there's an innocuous question? Moreover, knowing that domestic violence courts are quite busy, and these matters are handled on a quite expeditious basis, forcing a trial judge to have a question-by-question analysis on the record is going to cause some judges to have a stroke. None of them that are up here, of course, but suffice it to say. Well, now we have the final word from the Supreme Court on how the Fifth Amendment is to be used. It's not a blanket immunity, it's question by question, but please be reminded, the Fifth Amendment is no panacea. These cases are he said, she said cases, domestic violence matters. And if the defendant's not going to testify, it's going to be pretty hard to win that case. So the only time you're really going to be considering this Fifth Amendment, at least in this context, would be when the allegations like in MA are so weak that you think you could win the case just on the strength of the plaintiff's testimony. We go to case number 3, in re estate of Michael D. Jones, 259 New Jersey 584, 2025. And again, it's another retread case. The Appellate Division decided this case in a published opinion in 2023, and I reported on it in the 2024 symposium. This is now the Supreme Court's decision in the Jones matter. It's a United States savings bond case, right, where the parties get divorced and the husband receives the savings bonds as part of the divorce. But he never changes the beneficiary, and the beneficiary is his ex-wife. After the divorce, the husband gets ill, and who's going to take care of the ill husband? Well, of course, the ex-wife. And as she's in the house, and of course he passes away, she discovers the bonds. She discovers she's still the beneficiary of the bonds. She takes the bonds to the bank and she cashes in $77,000. Well, as luck would have it, the husband had a child from a different relationship, and that child is now the executrix of the estate. She finds out about the bonds, and she wishes to claw them back into the estate. Trial court rules in favor of the daughter and says, wait a minute, there was an agreement here. And the agreement said that the ex-wife gets certain lump payments that she was entitled to, and all the other assets belong to the party who had possession. The husband had possession of the bonds, they belong to the estate. Moreover, we have a state statute here in New Jersey, 3B, 3-14, that says these beneficiary designations get automatically revoked upon divorce. The wife's not satisfied with that decision, goes to the Appellate Division. The Appellate Division sees it completely different. They rely upon federal law, which says that, hey, the only way you can change or redesignate the beneficiary of a U.S. savings bond is for the bondholder to go to a bank and fill out that magical form. Not having done that in this case, federal law applies and preempts any state statute that otherwise would have revoked that beneficiary designation upon divorce. Now comes the New Jersey Supreme Court that takes the case up on cert. You thought maybe they took it because they were going to do equity or justice or something like that. You're wrong. They affirm the Appellate Division decision, albeit on different grounds. It finds that under the New Jersey statute, it doesn't apply to U.S. savings bonds. So I don't have to decide the preemption issue because it doesn't apply. The court then goes on to rely on a broad catch-all provision in the parties' settlement agreement that said, quote, any marital asset not listed below belongs to the party who has it currently in their possession. So remember, the U.S. bonds are not actually listed in the agreement. This catch-all phrase meant it was the husband's. The Supreme Court says, yeah, it was the husband when he left the courthouse, but when he died under federal law, it became the wife's property, and therefore the wife wins. Far beyond the issue of U.S. savings bond, however, this case provides the clarion call to all practitioners to be on guard of the potential of death in your divorce case. First, you should heed what John D. Bartolo's panel did last night. They did a great job, and John certainly deserved this award today. Let's hear it for John. What I'm saying to you is when a client comes in for a divorce, the first thing you should do is ask, do you have a will? And if you have a will, should it be changed? Because the divorce complaint doesn't revoke the will. You also should go over with the client all instruments with a beneficiary vehicle to it. Do they need to be changed and redesignated? And can that be legally done? You have to think about death and divorce. Case number 4, Rappaport versus Pasternak, another Supreme Court case, 260 NJ 230. This is not a family law case. But in a day and age when most of us have cases that are going to binding arbitration, Rappaport is a must-read because Rappaport addresses your alternatives when you are dissatisfied with the decision of the arbitrator. And the simple answer is that unless the arbitrator is dishonest, or unless the arbitrator commits a basic math error, 1 + 1 = 3, or unless the arbitrator acts beyond the scope of the arbitration agreement, you cannot come to court and say, please, trial judge or appellate division, correct the errors and abuse and discretion of the arbitrator. The court's role is there mostly as a summary proceeding, governed strictly by the statute. And if you don't hit any of the magic criteria under the statute that I've already explained, you're not going anywhere. So, in most instances, if you're looking to challenge the arbitrator's award, your best chance is claiming that the arbitrator acted beyond the scope of the arbitration agreement, which is what happened in this case, or at least what was claimed in this case. The clearest example would be if the arbitrator awarded relief against a third party that was not a signature to the arbitration agreement, or if the arbitrator decided an issue that was specifically not put before the arbitrator. But beyond that, Rappaport tells us that the court is going to defer to the arbitrator's award. The court restated its long-standing position, quote, arbitration awards should be what they were always intended to be, final, not subject to judicial review, absent fraud, corruption, or similar wrongdoing on the part of the arbitrator. Whether the arbitrators commit errors of law or errors of fact should be totally irrelevant. The only questions are, were the arbitrators honest, and did they stay within the bounds of the arbitration agreement? The court reminds the parties that if you have a matter that you want to have certain issues exempted from arbitration, you better get it in writing. If we're going to arbitration with our full divorce case, the judges can decide alimony, equitable distribution, child support. If you don't want the judge to decide one of those issues, get it in writing so it can be X'd out, especially if the arbitrator oversteps his or her bounds. So in the end, make sure you select an arbitrator you can trust, one of our retired judges, or perhaps you go to the American Academy of Matrimonial Lawyers website, you get a list of certified arbitrators. If you're still worried about the runaway arbitrator, include an appellate arbitrator in your arbitration agreement, and then you'll be able to get the kind of appellate review that you lose once you go to binding arbitration. Case number 5, Voynich versus Voynich, 481 New Jersey Super 207. This is my candidate for the most important case of 2025. So now you gotta pay attention. This is a retirement case, but the party settlement agreement was entered into in September 2003, which is prior to the 2014 amendments to the statute of alimony. This means that the case is controlled by NJSA 2A:34-23J3, which says that when an obligor is eligible for full retirement benefits under the Social Security Act, that is a good faith retirement age. Good faith retirement age, what the hell does that get me? Under the Act, after 2014, if you hit the full retirement age under Social Security, that raises a rebuttable presumption that alimony should be terminated. That's not true with regard to these pre-2014 agreements. So all I got so far in this case is we hit good faith retirement age, there's no rebuttable presumption that alimony terminates. But wait, this statute's got another provision in it. It also says, in making its determination to modify or to terminate alimony, the court shall consider the ability of the obligee, the person who's receiving the alimony, to have saved adequately for retirement. And it's the appellate decision's interpretation of that language in this case that makes Voynich the most important case of the year, in my opinion. The facts of the case are pretty straightforward. It's a long-term marriage. Husband owns a veterinary practice making $400,000 a year. The wife is working as a bookkeeper for the practice, but she's primarily responsible for caring for the children. The husband agrees to pay alimony, permanent alimony, you might have heard of that word once before, of $10,000 per month, commencing in 2003. And although the agreement doesn't address retirement, there's language in the agreement that says, specifically, this agreement does not include an anti-lepus clause. In 2020, the husband sells his veterinary practice, but he keeps dutifully paying his $10,000 per month. And he does so until April 2023, when he reaches full retirement age. And now he comes to the court and he says, Your Honor, I had enough. Terminate my alimony. He certifies that he has no earned income, but he does have $8 million in assets. So now let's stop for a moment because this is the audience participation part of the program. You do the math for me. Let's assume a rate of return of 5% on $8 million. What do we have? I heard $400,000 out there. I'm giving you half credit. And how much did the husband say that he was earning when we fixed the alimony award? $400,000. It doesn't sound like this case is going to go very far. Well, anyway, after the divorce, the wife moves to North Carolina. She does not go into the workforce. The wife's asset at the time of the motion about $2.75 million. And the husband alleges that she's got an inheritance of $200,000 that she hasn't disclosed, and she also has an interest in a trust that constructed a $2 million house for her on a lake in North Carolina. At oral argument, the trial court denies the husband's application, finding that he has not met his burden to show a prima facie change in circumstance. Meaning the judge was more or less like you guys and said, hey, the guy's got $8 million. How do you prove that you can't pay the $10,000 a month alimony if you got $8 million? But the judge goes a little further too. And he says, you know what? The word retirement's not in the agreement. Therefore, I also find that you kind of waived your right to even be here and argue retirement. The defendant, the husband, appeals, and the appellate division immediately reverses the trial court with regard to this business about the word retirement is not in the agreement. What was in the agreement was that there is no anti-lepus clause. Lepus includes the change in circumstance for reasonable retirement. So you didn't have to actually designate the word retirement as one of the grounds for a change in circumstance. So that's number one. But then the appellate division says, you know, I agree with this audience and I agree with the trial court. $8 million, the husband has not met his burden to show a change in circumstance. But here's now the payoff. The appellate division says, but that's not the end of the inquiry. The statute requires the court to consider whether the obligee had adequately saved for retirement. With Voynich now, the appellate division gives life to the statute and speaks to the obligee having saved to retirement. And now it's possible that even if the obligor has the financial basis to continue the alimony award, he may gain relief if 1, the obligee has adequately saved for retirement and no longer has the need for alimony, or 2, the obligee had the ability to save for retirement, and had she done so, would no longer have had the need for alimony. The appellate division makes clear that the obligor continues to maintain the burden, but the obligee is now required to produce competent evidence that she was unable to adequately save for retirement and has a continuing need for alimony. As the wife failed to provide this information, and as the husband challenged her ability to save, the matter was sent back for a plenary hearing. This is a very important case, and I think you're going to hear more about it today. I think Cassie Murphy's got a panel that's going to address it in part. It reminds us that in those pre-2014 cases, you don't meet your burden just by showing up to court and saying, I've reached full retirement age. What that does for you, however, it gets you past the question of whether or not your retirement was voluntary or not. We no longer go into your motives for retirement because you've reached good faith retirement. Now the question is the financial circumstances of the parties, and now the obligee's ability to have saving. Keep in mind one other thing about when you're looking at these retirement cases. We are focusing particularly on non-exempt assets. I don't mean non-exempt in the equitable distribution that way. I mean non-exempt from the point of view of the court is not to be looking at those assets that existed at the time of the divorce in order to impute income from them. That would have been the double dip. Remember Innis versus Innis and Justice Law? And so now, if I change the fact pattern that I gave you earlier, and I told you that yes, the husband had $8 million, but $5 million of that 8 came from the sale of his veterinary practice, would your answer be the same? Perhaps not. I suspect that Voynich has opened the proverbial Pandora's box, and we'll be hearing more from the courts about retirement. Case number 6, Vandy Endy versus Philip Reynolds, Appellate Division decision. This is a reported case where our chair-elect of the section, Christine Fitzgerald, is the prevailing attorney. Congratulations, Christine. The parties are married in South Africa. They have a child in common in South Africa. Prior to the marriage, they signed some kind of a document in South Africa which appears to be akin to a prenuptial agreement that says any of our assets in South Africa are going to be divided in accordance with South African law. By 2017, the wife moves with the child to New Jersey. The husband's supposed to follow, but he doesn't. He stays in South Africa. By 2021, the wife files a complaint for divorce in Morris County. She's seeking alimony, child support, custody, and equitable distribution. She acknowledges that there's this instrument in South Africa, but she says it's invalid. The husband, who's still in South Africa, joins the case. He files an answer and counterclaim. And he acknowledges that the court has personal jurisdiction over him to decide alimony, child support, child custody, but not the division of the assets in South Africa. After a while, the wife has to file a motion for discovery because the husband's refusing to provide it. The husband files a cross motion with regard to getting the South Africa assets out of the New Jersey proceeding. While this is happening, he's also in South Africa trying to get a court to hold that the South African agreement is valid and enforceable. What does the New Jersey motion court do? Denies the wife's request for the discovery and grants the husband's request to dismiss the wife's equitable distribution claims, stating that the court doesn't have subject matter jurisdiction over the assets in South Africa, and as a matter of judicial comity, C-O-M-I-T-Y, it will defer to the proceedings in South Africa. The wife files a motion for reconsideration in front of the same judge, this time produces an expert's report from a South African law expert that says, hey, South Africa can't handle the case because you can't get jurisdiction over the wife who's a New Jersey resident. Notwithstanding this, trial court reaffirms its prior dismissal of the wife's claims and the wife files for appeal. The appellate division reverses the trial court and directs a hearing before the trial court on the issue of jurisdiction. And the reason why it looks like Christine's going to win this case is because on remand, on its face, it would appear that New Jersey is the only place where the division of all the assets can be perfected. New Jersey is the only forum that has personal jurisdiction over both of the parties. And New Jersey, which also has to decide child support and alimony, is going to need to have its hand in the asset distribution because those issues are interrelated. When I look at this case, I ask myself how the trial judge got it so wrong. And I think what happened was the South Africa connection probably fooled the court a little bit, because if we were dealing with a prenuptial agreement that was executed in California, and it said that the assets have to be divided in accordance with community property law, the judge wouldn't say, well guys, you gotta go back to California, decide that issue there, then come back here, we're gonna do equitable distribution of the remainder of the assets, and alimony, child support, child custody. Of course not. The New Jersey judge would have put on her California hat and decided everything in one forum. Case number 7, the final case for you this morning, is AC versus RS. It is an opinion authored by our longtime friend of the family section, Judge Annie Mala. It's a VASPA case, and VASPA is an acronym for the Victims Assistance Survivors Protection Act. Now, if you're going buggy by this time with all these acronyms, you're right, because VASPA used to be SASPA, the Sexual Assault Survivor Protection Act. When the legislature expanded the original law to include stalking and cyber harassment, they changed the name. Persons not eligible for protection under the Prevention of Domestic Violence Act, because they do not meet the jurisdictional definition of victim. You know, spouse, child in common, dating relationship, living together in the same household, can apply for protection under VASPA for acts of non-consensual sexual conduct, lewdness, stalking, and cyber harassment. This case focuses primarily on cyber harassment, and that's under NJSA 2C33-41, defines cyber harassment to include one or more communications made in an online capacity with purpose to harass another by threatening injury or physical harm to any person or the property of that person. Here, the parties don't know each other, so of course, the domestic violence statute wouldn't apply. The plaintiff is in a romantic relationship with the defendant's husband. And when the defendant finds out about it, she goes to the plaintiff's house. And she starts ringing the doorbell and nobody answers the door. She starts banging on the windows. And who finally comes out but the defendant's husband? And at that point, she kind of loses it. She's not leaving. She wants to see the plaintiff. They have to ultimately call the police and she agrees to leave. But she's not finished for the night. She now proceeds in sending 10 text messages to the plaintiff, making disparaging statements about the plaintiff and threatening to reveal information about the plaintiff having an affair with the defendant's husband to the plaintiff's employer. The defendant never threatens injury or physical harm to the plaintiff herself. Most of the text messages can best be described as sexual boasts by the defendant and a threat to contact the plaintiff's employer to let them know that the plaintiff is having an affair with a married man. Through it all, the plaintiff does not respond to any of these text messages. Instead, the plaintiff files a VASPA complaint against the defendant alleging stalking and cyber harassment. Plaintiff obtains a TPO, which is a temporary protective order. At the final hearing, defendant testified that she was upset that her husband was having this relationship which was only 2 months after a complaint for divorce had been filed between the parties. Defendant testified that she did not intend to physically appear at the plaintiff's place of employment. She only wanted to let the employer know that the plaintiff was having an affair with a married man. The trial court finds that the plaintiff does not meet her burden to prove stalking, right? Because this was a single incident where she showed up at the plaintiff's home, and this incident did not meet the statute's requirement of repeated conduct. However, the trial judge did find that the plaintiff proved cyber harassment, as the defendant's threat of notifying plaintiff's employer was a threat of harm to the plaintiff's property. Hear that? My job is my property. So that's important that you remember that, right? Trial judge also finds cyber harassment by defendant's lewd comments regarding describing what the defendant and she were doing sexually together. As a result, the trial judge enters an FPO, final protective order. Defendant files an appeal. First, the defendant argues that the claim of cyber harassment should be rejected on its face because the comments were not made online, they were not made on social media, but only through a text message. So here, the Appellate Division makes law by rejecting this argument and finding that text messaging is within the type of electronic communications which can be deemed cyber harassment under the statute. Second, the Appellate Division reverses the trial court's finding of cyber harassment on the basis of the lewdness because it finds that, at best, the defendant's bragging about her sexual prowess and her text messaging of that information doesn't meet the test of lewd conduct. As to the threat of contacting the plaintiff's employer, the Appellate Division agrees with the trial judge that screwing around with somebody's job is their personal property. But it finds that here, the only thing that the defendant was looking to do is to tell the truth to the plaintiff's employer, and that in and of itself couldn't constitute a crime of cyber harassment, and as a result, the matter is dismissed. And that, ladies and gentlemen, are the top cases of 2025.